to react to what was just read out. They did. We considered all the views. We rose to consider the views. We did consider all the views by learned counsel. And we came out with a statement reflecting what learned counsel thought would be the proper stance of the commission. I will read out the decision arrived at in chambers, reflecting what learned counsel, their own reaction to what I read before. 1, representation by counsel. The commission accepts that under Section 18 of the Tribunals of Inquiry Act, any body mentioned in a petition has a right to representation by counsel. The only question that may arise is that such counsel should restrict himself only to the issues affecting his client, either in response or in cross-examination. 2, we also came to agreement that representation by the middle belt or any other interested party, the council gave audience to the commission rather, gave audience to the council representing the middle belt during its sitting in July 2001 in respect of this matter. Unfortunately, that day, their name, the middle belt was not clearly indicated on the cause list, and we apologize that that was so. And we said that omission was regretted. The commission, however, maintains that it is not responsible for any publication in the media. So if the media said the middle belt, we are not allowed to present a petition, that is not our business. We didn't say so. We allowed them the facility to come before the commission and present their case, which they have done. Their counsel cross-examined all the witnesses. On the issue of number of days for the petitions between the Ohanese and the Arewa, in Enugu, the Ohanese petition was heard along with other cases for 4 days. In Abuja, second sitting in July, the response filed by the Arewa Consultative Forum was heard for 2 days, along with other cases. We heard them and they said it's better for the commission to relax a bit of this rule and allow them to present all their cases. That we agreed. We are all in search of what will heal the wounds of the nation, not what will divide us more and more. We also had from Arewa's petition a very, very serious challenge that effort will be made in this commission to have an agreed picture of what happened in Nigeria between 1966 and 1999. If that is so, it will form part of our history, deposited in the archives, be taught in schools as a history of Nigeria. That challenge we have accepted. We will do our utmost to see that we have the true picture of facts. During the course of hearing, we received many, many publications, more than 20 now. Each one approached the subject matter of what happened in Nigeria from 1966 to 1999 from its own angle, using its own glasses. That angle is personal. We want an objective, not subjective angle. So that when we say this represents what happened in Nigeria, between 1966 and 1999, we will not be deceiving our children and grandchildren as to the fact of our history. That is what we all agreed on the first day of the public hearing of these petitions. I just wanted to mention it so that we know from where the terminus a quo, in order to arrive at the terminus ad quem. I think that's enough now. We can now call. Is there any short case we can take? Any short case we can take before 11 o'clock? What about Major Nyang? Any short case we can take?
Excuse me, my lord.
I ask questions.
My lord, the Medonia is straightforward enough.
Huh?
It's fairly straightforward.
Which ones? Yes? Tuesday. September 11th.
My
So,
lord,
number one then, yes?
my lord, sorry, sir. I'm sorry for taking the time of this commission, but it has become necessary for me to just make an observation.
Louder so that I can record you properly. Yes,
Yes, my lord. But it has become very, very necessary at this point for me to make an observation, sir. At the time this Honorable Commission resumed this sitting in Abuja, I was not around. But I am happy with the generosity of the Honorable Chairman having restated or reread the address that was read on that particular day. And then the comments made about the press and the conduct of counsel. My lord, I am very, very grateful about that, and I want to pledge my commitment to abide by the particular rules of this commission throughout the residue of the sitting. But my lord, there is a publication I want to draw this honorable commission to. It is the Insider magazine.
In respect of what case?
My lord, it has to do with a case that is pending before this honorable commission. And this,
On the list?
No, my lord, this publication came
Hold
up.
it. Is it in respect of any case on the list today?
It is not, my lord, but then in one of the cases that is coming up today, a matter pertaining to this to that particular case in which this publication is relevant was mentioned. At least the issue of...
When we reach that case now, bring up the point, then we can record.
Well, my lord, I just didn't want at the middle of the proceedings to disrupt this commission. That is why I wanted to take this observation at the onset. So that at the end of the day, my lord, I wouldn't have at the middle of the commission sitting seem to be interrupting the flow of the proceedings, my lord. Well, my lord, I would drop it if my lord is not disposed to taking it. But I was just going to make a very, very brief observation on it.
Saying we are not disposed. I'm not saying raise it when the case comes up for hearing.
My lord, sir.
Will you lose anything raising it at that time?
I will, sir. Now that my lord has repeated the conduct of press, conduct of counsel, I should also raise it so that along the line, my lord could also make one or two comments about the conduct of the press. Because, my Lord, what I'm trying to say in essence is this. We have on very several occasions restated our implicit confidence in the sense of justice of this Honorable Commission. And, my Lord, we are very, very sure if there is any member of this commission who, for any reason at all, at any point in time, cannot perform the responsibility bestowed on this commission from the platform of justice and fairness, I am very sure that such a member will be asked to be relieved of that position. My Lord, justice demands that any matter that is before this commission shouldn't be interfered with. My Lord, the case of Abiola is before this commission. The press has come up with a publication that my client, who has been in prison since the 13th of October, 1999, has made a confession that they agreed to kill Abiola. My Lord, when was this confession made? To who was this confession made? Where was it made? My Lord, there are people who are not happy with what this commission is doing. They also would work against getting to the roots of the matters that are being investigated by this commission. So, my Lord, in view of the fact that the platform upon which this commission is operating is justice, anybody who does anything with the intention to impede justice in this commission should be brought to book. It is in that particular regard and perspective that I am urging this Honorable Commission to order a thorough investigation into this particular publication. Because this matter, my Lord, there is no overemphasizing the importance of the case of Abiola, both nationally and internationally. My Lord, some people are there scared because they know we will get to the root of this matter. They know at the end of the day, those who have been dignified wrongly will be identified, and spades will be called spades at the end of the day. They are not happy. They don't want us to make any progress. They don't want us, this commission, to achieve justice in its investigation. That is why they keep making publications like this. It is because of that that I want to draw the attention of this commission and also pray that this commission should order a thorough investigation of the source of this particular confession. The source magazine, the person who said that confession was made, whoever the source is, and my Lord, above all, there is no journalist that can claim that he has a duty to protect his source. We are talking about a national interest which overrides the interest of any particular individual or corporation. My Lord, that is my humble request, and I urge my Lord to favorably consider this request that I have made. Thank you.
I wish you referred me to a section of the Act. There is a section of the Act dealing with what you are saying. You haven't referred to it. Then if we're going to make any... But I've noted your observation. I still say, when we come to the case where it is relevant, we will revisit it. Thank you.
With the
we can't go on council after council stand up to say
my Lord, it's very short. My Lord, I will say that some of us were not here, but we
are not hearing you well.
Oh,
speak up so that I can record your voice.
Yes. My Lord, just as my learned friend Yakubu had said, some of us were not privileged to be here at the opening of the second segment in Abuja, but we have been very active participants in this commission. And it is possible, my Lord, that in the course of our duty to the commission, to the cause of justice, to our clients, some of us may have run foul of your Lordship new Riot Act. My Lord, we do apologize if we did. But my Lord, I will also say that because of the seriousness of the tenets of justice, my Lord, which this commission, apart from which this commission cannot do without taking every fact into consideration. My Lord, I wonder what your Lordship will do in respect of petitions that have come before your Lordship and we were not privileged to cross-examine on those petitions, and we had made our views known to your Lordship on the desirability of resummoning, so to speak, witnesses who had earlier testified. My Lord, I'm saying this in particular reference to petition 654, that of Benga Obasanjo, and the fact that, my Lord, I had in particular drawn your Lordship attention, the Commission's attention, to the fact that we were not privileged to cross-examine on that petition, especially as it relates to my client, Major General Aziza. And your Lordship was of the view that it would be necessary to resummon the witnesses who testified, particularly Mr. President. My Lord, that petition is not before your Lordship this morning, but the petition of Dr. Becker Kuti is before your Lordship. I don't know whether, my Lord, in the interest of justice, will either give us an opportunity to do so, or will make it possible for Mr. President to be resummoned.
As you say, in the interest of justice, the case before us is a case of Becker and Kuti, and we'll confine ourselves to that today.
My Lord, the other aspect, I don't know whether your Lordship will resummon Mr. President to answer questions on 654 in the interest of justice.
The case before us today is that of Ransom Kuti. That is where the president is involved. There is no other case before us in which the president is involved. Yes, call the case.
That's number one, please.
Yes. 1404.
As the commission places. Petition number 1404. Major Nyang I. Nyang. Major Nyang I. Nyang. Petitioner present, my Lord. Petitioner present, my Lord.
Appearances. Appearances, please.
Respectfully, my Lord, distinguished members of the Commission, I announce my appearance for the Honorable Commission. My name is Mrs. Chinwe Owandu. Mr. Emmanuel Akaka will be appearing with me.
Now, this petition was struck out for non-appearance with leave to...
With profound respect, my Lord, I am YC Michael. The following learned gentlemen appear with me: T. George Tendezwa, Lydia Joe Madugu, and Victor C. Nwao, all for General I.R. Bamaiyi.
May it please your Lordship and members of the Commission, my name is Umar Shitian. I humbly appear for General Sabo, Ibrahim Sabo.
May it please, my Lord, I appear for Major General Patrick Aziza. My Lord, like before, we have not been served, but our names are mentioned.
Any other appearances?
My Lord, he said he was going to be around.
No,
No. I mean, it's not a question. We would like to see General Aziza as an attraction, but I mean, is his name here?
In fact, my learned friend was just telling me that his name is mentioned.
No, but what we have, it doesn't contain his name. But can we?
Excuse me. Your Lordship, as a matter of, I just mentioned to Princess Akiri that her client's name was mentioned in passing. It was meant as a joke, actually. But
You know, we're gender sensitive, and we like to take seriously what. So we just take it that it was a joke between the two of you. Okay, let's.
My Lord, it will. In fact, as I said, she told me, I have not been served. She said my client was mentioned, and it is not that I'm knowing. My Lord, it is only necessary if he was mentioned, and I'm here to announce my appearance, my Lord. It was on that vein.
All this. Now let's make progress. Have you got a petition? The princess, you haven't, which means they didn't consider that your client was really.
Well, my Lord, it has not always been the case, because even the serious
All right,
one
I'll
of.
give you a copy.
As a Lordship, please.
Where in the body of the petition did they mention that your client this or do that? Not the heading, the body.
Well, until I look
So
at it.
there must be something.
Until I look at it, my Lord.
We haven't even looked at it, and you're appearing.
Your Lordship has just heard that I was told, and that was coming from the council to the commission, my Lord. I mean, there have been cases where we came here, we were not served. We read on the pages of newspaper, and evidence was given here, even though we were not served, my Lord. I mean, it is only fair.
All right. Yes. Has he got a lawyer?
my Lord is not represented by counsel.
Well, you leading him.
As my Lord, please.
Go on then.
Please swear him.
Can we make progress?
Please swear him.
I, Major Nyaitanya,
Do solemnly swear
that the evidence I shall give
that if the evidence I shall give
before this honorable commission
shall be the truth, the whole truth,
and nothing but the truth.
so help me God.
We don't have the complete petition. This is one. The elections are not complete. We don't have.
Major Nya, your full names, please.
Major Nyaitanya,
Please speak up. You are being recorded. Musa.
Major Nyaitanya,
Major who?
Nyaitanya.
What is your address?
My address is Usunwesogodot, my village.
I can't even hear you from here.
Usunwesogodot. Usunwesogodot. Usunwesogodot, OputaPanel in Cross River State.
And what do you do for a living?
I have no job.
Now, Major, did you forward a petition to this Honorable Commission?
Yes, my lord.
Please take a look at this document. Is that your petition?
Is a copy of my petition, my lord.
Your Lordship, I seek to tender that in evidence.
Exhibit 1, mark it and give him to read.
As my Lord pleases. Did you also prepare an addendum to your petition?
Yes, my lord.
Please look at this.
Is it the addendum?
Yes, my lord.
Your Lordship, I seek to put that in evidence.
Addendum Exhibit 2.
As my Lord pleases. Please read Exhibit 1.
The Chairman, Human Rights Violation and Investigation Commission.
Hold on. Mrs. Wandu, can we go back? First of all, we've dealt with this case, haven't we?
The case was struck out in Enugu further. The case was struck out because the contents didn't quite well agree with the terms of reference of the commission then. It was struck out, but he was given leave to, file it again, to refile. The petition has now been amended and it's been relisted.
No, but what is, because first of all, if you look at page 2, I've not read the full petition, but if you look at page 2, it still contains essentially the issues that were raised in the first petition. And central to it is the fact of, if I remember well, this party that he attended at the American embassy, which was part of the whole thing, that seemed to have been purely and simply a matter of military discipline. And talking of which, General Aziza is copiously mentioned. So unless it is a new petition that we're dealing with, it doesn't, what we have here is definitely not what we had when we all started. And the addendum here is essentially, as I said, dealing with basically the same thing, except cast in a slightly different language. So I don't know whether you've had a chance to go through it and then decided to release it for hearing today, because the issues are still basically the same.
Well, yes, we have had the privilege of going through the petition, and we crave the indulgence of the commission to hear the petition, because apart from the party, the petitioner stated that he attended, which of course, as you rightly pointed out, sparked off the chain of events. The petitioner also complains about severe torture, detention without trial for a very long time, which formed the kernel of the gross violations of his rights. We crave the indulgence of the commission to allow the petitioner to read his petition.
Lord, some of us here do not have a copy of the addendum, Exhibit 2.
My Lord, sir, aside from not having, as my learned friend has said, what is served on my client was the petition that was struck out. It is only now that I'm being served with the amended petition without releasing the old one with an addendum. And my Lord, I have just quickly looked at it. There are a lot of allegations contained in the new one and the addendum, which were not in the earlier one struck out. And that this petition has just been served on me now and here. My Lord, we are talking about violations of human rights. My client is in prison. Is he not entitled to adequate opportunity to defend himself? Should his own fundamental right be violated in the quest to redress another violation of fundamental rights? My Lord, I think we should be given every opportunity. We are not saying it shouldn't be hard, but we should be given the opportunity to adequately prepare for our defense.
Everybody who has been mentioned getting involved and presenting their own case, my Lord. There's no way. My Lord, when I announced my appearance, it was like a joke, or it was like I was meddling where I'm not supposed to meddle. But it is so clear from pages 1 and 2 that we are seriously implicated by the Exhibit 1 and Exhibit 2. So, my Lord, I don't know, giving regard to your Lordship stand that there will be no adjournment, and we are just being served, and this is a commission to redress human rights violation. I don't know how we can do it. My Lord, I need to be briefed in respect of this particular petition, although I have a standing brief to answer to all matters relating to General Aziza. My Lord, I cannot do it in the absence of a specific briefing in relation to this petition. But that is my stand. I can be overruled on the issue of adjournment.
Sorry, Mrs. Nwandu. Mrs. Nwandu.
Sir.
I'm a bit confused myself. Is there really an amended petition or an addendum to the first one struck out? Because what I have with me is an addendum to the main petition. And I heard one or two council talk about an amended petition, which I don't have. I mean, so can you clarify the position? Is there an amended petition?
Well, sir, as far as
addendum?
As far as we know, sir,
Yes.
the first petition which Learned Council, that's Yakubu, made reference to, was struck out in Enugu. So for all intents and purposes, I suppose that petition is dead. The petitioner was given liberty to release his petition, which he has now done. And that is what we have served on Learned Council.
Which is this?
Plus an
Caption,
addendum.
is this one, caption an addendum to the main petition? Or is there any petition, caption amended petition?
No, sir, there's nothing of the
This is
sort.
the one.
Yes, what we have is the petition which has now been relisted and an addendum to that petition.
Okay.
The one of Enugu, of course, no longer exists.
Yeah, just...
Sorry, my lord, the heading does not matter. It is the contents. My lord, what he has brought is
Why
not the
don't we
one
go
struck out.
in and do something, some of all these speeches?
Yeah, my lord,
You give evidence. If at the end you can't cross-examine, you ask for adjournment. It's as simple as that.
Well, my lord, it is
We're all lawyers,
important.
you know.
We should bring it to the notice of the commission at the onset.
At the end, if you can't cross-examine, you say so. Not before the man says a word. And we wasted half an hour talking to ourselves about nothing. Now, the only thing is, was this struck out because they were not there or because the petition?
He was right there in the witness box in Enugu when the petition was struck out, my lord.
For?
As far as I remember, my lord said there was some kind of trial. My lord, maybe the petitioner will remember better. And my lord said, since there had been a trial, that's put it outside your lordship's jurisdiction. But my lord, he claims he did not receive a fair trial, and he was also detained and tortured. That is the crux of his petition, my lord.
Now, what do you want us to do? You are counsel for the, you want to go on?
Oh, most certainly, my lord.
Examine him. Let's go on.
Yes, my lord.
Then those who can't cross-examine will ask for a date.
Please read exhibit
If they
1.
give a date after the commission winds up, it's all right. But let's go on.
The Chairman, Human Rights Violation Investigation Commission, Federal Secretariat, Abuja. Memorandum. Sir, petition against my illegal detention, torture, imprisonment, and wrongful removal from the Army by General Bamaiyi, Brigadier General Patrick Aziza, Colonel J.B. Yakubu, and others, now retired. Introduction. This paper is produced to give a pen and graphic picture of my inhuman experience during my detention from 2nd April 1996 to 2nd April 1997, both in Security Group and Kirikiri Maximum Prison. During this period, I was thrown into DMI deadly interrogation tunnel at Park Lane, Apapa, for 7 days. An attempt to poison food for me at the National Intelligence Agency guard room at Bonicam, and assassination attempt on me at Kirikiri Prison through the Provost Marshal, Nigerian Army, then Brigadier Ikbo Chibong, now Major General, GOC 2 Division, Ibadan. Of course, it's retired now. The removal of my 2 cars and money from my residence by intelligence personnel on the orders of General Bamaiyi, Brigadier General Patrick Aziza, and Colonel J.B. Yakubu, and others. Aim. The aim of this paper, therefore, is to give this commission a vivid mental picture of what the trial of General Ishaya Bamaiyi, Brigadier Sabo, and Frank Omenka, all retired Army officers, made useless my 30 years of military service to this nation. 1, I was wickedly detained, tortured, and jailed 18 months by Brigadier Sabo, retired, the former Director of Military Intelligence, on the order of the retired Lieutenant General Ishaya Bamaiyi. I was detained on 2nd April 1996 until 2nd April 1997 when I was released from maximum security prison, Kri, Lagos. I am 53 years by the time of this petition. I'm 55 now by 18th of this month. I'm from Calabar, Cross River State. I'm a father of 14 children and with an old mother and numerous dependents. I joined the Army in April 1968. Most of my children are out of school now due to my present situation. My PJ 54 station wagon bought through car loan was seized as well as my Mercedes-Benz car confiscated to unknown destination. My personal belongings were thrown out of my residence at Ojo Cantonment as if I was a thief. My wife and children were driven out from my residence and sent out of the Army schools in Lagos as if I was a murderer. I was inhumanly battered, and my once humble family brutalized. My offense was disobedience to standing order in that I attended a dinner party in the residence of United States of America Defense Attaché Major Ingram. Please see attached photocopy of this obnoxious charge. Now the charge. 4, Your Lordship, this is what happened. I am one of the victims of Abacha cruel rule in Nigeria. I was the Assistant Director of Army Public Relations posted to Lagos Garrison Command from 1994 after returning from active service in Liberia, ECOMOG. My schedule of duties include those functions of a protocol officer in civil establishment. My office was as a vehicle of communication between the Army and civil populace. I invited, received, and represented the Army in most military civilian functions. On the 24th March 1996, I received an official invitation from the United States Defense Attaché in Nigeria, Major Ingram, to attend a birthday party, parking my car outside his residence at Providence Street, Ikoyi. On the 1st April 1996, Monday, I got a signal message from the DMI that I should attend an interview with him on the 2nd of April 1996, following day. That night, I reported to the then Major General Bamaiyi, who was then my commander in Lagos Garrison. He advised that I should attend and report back to him. Accordingly, I reported to the DMI Apapa at 8 a.m. I was not attended to till 4 p.m. That was the beginning of my traumatic 12 months of mental and physical torture. When I was invited, I met Colonel Sabo DMI, Colonel Azazi, please, the right Aziza is wrong. It's Azazi, his Colonel GS, and Lieutenant Colonel Frank Omenka. I'm sorry it's not here. CO Security Group. The trial constituted a panel that interviewed me. I was asked where I attended a party recently in Ikoyi. I told them Major Ingram's house and the nature of the party. They showed me a letter. Please, there's a copy of the letter here. It's attached to my petition. Warning military personnel not to associate with diplomats. I told them I have never seen such a letter, else I would not have honored the invitation. I told them that even 11 days before that day, that is 26/02/96, many defense attaché from foreign missions in Lagos were invited to a party in Lagos Garrison Command by my office after due clearance from my commander. If such a letter was given to us, the LGC command would have stopped us from inviting them. I was ordered to be detained in the security group commanded by Lieutenant Colonel Frank Omenka. I wrote statement before commencing my 12 months incarceration. For 7 days, I remained incommunicado. During this period, Your Lordship, I went through terrible inhuman treatment in the hands of Lieutenant Colonel Frank Omenka. I'm sorry, Your Lordship is not here. I would have said this. I would have told this. I would have mentioned the whole story to the Commission. I was not allowed to see my family. I was left in the DMI interrogation tunnel for these 7 days. On the 31st May 1996, I was served with a convening order and charges signed by General Patrick Asiza, the new commander, Lagos Garrison Command. That day, I was taken under armed escort to 26th Battalion, Officers Mess, Bonny Camp. Here again, I was kept in another solitary confinement, that is the Defense Intelligence Guard Room. I believe this commission visited that place. It's a horrible experience. I was arraigned before a court-martial on Saturday, 18 May 1996. The court was presided over by Lieutenant Colonel J.B. Yakubu, who was compensated with the appointment of a military administrator in Zamfara State after jailing me. On Monday, 10 June 1996, I was found guilty of the 3 charges. Please see photocopy of the sentence. I'll produce this after this. With heavily armed soldiers, I was taken to Krikri Maximum Prison in handcuffs. This was where I was till 2nd April 1997 when I was discharged. Please see a copy of my discharge certificate from the prison. I brought it just here. Your Lordship, I joined the army during the Civil War in 1968. I fought the Nigerian Civil War and the Liberian Civil War in 1992-93. I am the first African to produce a live battle documentary film on ECOMOG operations in Liberia. That feat earned me letters of commendation from Chiefs of Army Staff, Nigeria, Ghana, Guinea, Sierra Leone, Gambia, and Senegal. Today, those films in 3 series are being used for training in most army formations and training institutions. I have the Chief of Army Staff, Nigerian Army letter of commendation here. I'll tender it, please.
Yes, go on, Major. When you finish your reading, we can tender them.
Your Lordship, I came to know that security personnel were trailing me for over 9 months because of the phantom coup trial of Generals Obasanjo and Yaradua. What happened was that a month after that trial in Lagos Garrison headquarters, General Ishaya Bamaiyi and Colonel Ibrahim Sabo that time, in a forensic manner, designed a grand deceptive program to rope more army officers into their pharaonic destructive game plan. A conference was called at Bonny Camp for all officers in Lagos. We were told to feel free to ask questions in relation to the coup trials of Obasanjo and co. They assured us that no one will be arrested or witch hunted after the meeting. Questions and observations by me were raised thus. Others asked questions before I did. A, I said, in the Army regulation and ethics, officers of superior rank sit as president of a court-martial to try officers of inferior rank. That General Obasanjo and Yaradua, though retired, were officers of superior ranks to Brigadier General Aziza, who was their court president. I then suggested, if we are not to set precedents, then the Army regulation must be amended to accommodate this flaw. 2B, I observe here that when the arrest of jail coup plotters were first reported in the newspapers, Brigadier General Fred Chichuka, then Director of Defense Information, came out with a refutal that those arrested were rumor mongers. 3 weeks after, General Abubakar, then Chief of Defense Staff, addressed the press conference that there was a coup and that those arrested were coup plotters, thereby contradicting Chichuka's, his Director of Information, denial on the same issue. I remarked that the denial by Chishuka and confirmation by his boss was a complete lack of cohesion on the part of our defense highest information outfit on such a sensitive national issue. As an information expert, Chishuka would have resorted to let me check techniques. The pressmen here are aware of that. You can tell somebody, let's check. Say tomorrow you won't answer. These were the basis of which I was sent to jail. Your Lordship, others basis I would mention to you orally here because I carefully wanted to avoid mentioning them because I don't know where they will go to. I will say more because as a public relations officer in the Nigerian Army for many years, I've known many officers and their activities. Your Lordship, I would like to plead with your commission to view my 12-month detention and imprisonment as an infringement on my constitutional rights. I was never given any fair hearing throughout the trial. I did not see any paper depriving military men from associating with diplomats. The charges, as you will see, were full of flaws. I did not appear before DMI for interview on the 28th March. Rather, it was on 2nd April. I did not meet or speak with any journalist on 2nd April. For when I was detained, I was left alone from 2nd April to 10th April. I made an appeal on the case to the Armed Forces Appeal Committee. But surprisingly, the Abacha henchmen comprising of General Patrick Aziza and General Bamaiyi and Colonel Franco Menka knew how unconstitutional the acts were, ordered the scrapping of that appeal committee without listening to our appeals. Over 23 senior military officers and 107 junior ranks were illegally thrown into prison in Lagos alone on trivial reasons after my trial. My case alone hurts the feelings of those who knew me within the NA and outside. This I say, people are watching me on the television, they will comment about this. I learned Liberians and those in Ekoma operation who knew me felt my country's army was wicked to me. My trial and conviction triggered up so many evil actions in the NA. That's why most of them are now in prison. Prayers. I humbly pray the Honorable Commission to hold and recommend to the President and the Commander-in-Chief of the Armed Forces of the Federal Republic of Nigeria as follows. A, that I was arrested and detained on 2nd day of April 1996 to 9th day of April 1996 in an underground tunnel at the DMI on the orders of General Bamaiyi, Brigadier Patrick Aziza, Colonel J.B. Yakubu, and Lieutenant Colonel Franco Menka, wherein I was subjected to inhuman treatment in solitude. That my arrest and detention mentioned above amounted to gross violation of my rights as entrenched in our Constitution. C, that my personal belongings, which included one Peugeot 504 car, one Mercedes-Benz car, cash of 840,000 naira, and my other household property, were carted away by soldiers on the orders of Lieutenant General Ishaya Bamaiyi, Colonel J.B. Yakubu, and Franco Menka, all of which are yet to return to me. That the unlawful carting away and seizure of my personal belongings enumerated in paragraph C above is unlawful and a gross violation of my human rights and as entrenched in our Constitution. E, that those gross violations of my human rights enumerated above are arrangement before trial and sentence by court-martial without giving me a fair hearing were all political in nature, as they were all masterminded by General Bamaiyi, Brigadier Patrick Aziza, Colonel J.B. Yakubu, and Lieutenant Colonel Franco Menka, only to score a pass mark before their Grand Master, General Sani Abacha. I will explain this. F, Your Lordship, that General Ishaya Bamaiyi, Brigadier General Sabo Ibrahim, Lieutenant Colonel Franco Menka, and Colonel Jibrin Yakubu and the Nigerian Army should apologize to me for the violation of my human rights and the false information they gave to the press that I was jailed for espionage, which has battered my personal image and reputation, which I have jealously guarded all these years. This apology should be done before this panel and also published in a national daily paper. I have the paper here. I will show the commission. 2, that I further humbly urge this honorable commission to passionately recommend to the President and Commander-in-Chief of the Armed Forces of the Federal Republic of Nigeria as follows. A, that I be paid the sum of 100 million naira as compensation in respect of gross violation of my human rights, viz., right to ownership of property, right to fair hearing, right to dignity of human person, right to personal liberty, right to provide family life, right to freedom of expression, right to freedom of movement, right to freedom from discrimination, all of which are entrenched in our Constitution, which these rights were infringed in my person. B, that I be paid all my salaries and entitlements from June 1996 till date, and that I be formally retired from the Army with all rights that I am entitled to, viz., fringe benefits, gratuity, and pension, etc. C, that I will be given a national honor in view of the fact that I served my beloved country, Nigeria, for a continuous period of 28 years within and outside this country. While in economic operations 1992-93, I won several awards and commendations from several ECOWAS countries in economic operations, including Nigerian Army Chief of Staff in 1994. Thank you for your kind actions, sir. God bless, and may He lead you with wisdom to emancipate some of us from our present inhuman predicament made possible by men of the same race like us. Signed, Major Nyang.
Thank you, Major. Please quickly read Exhibit 2.
An addendum to the main petition introduction. This paper is produced to give a pen and graphic picture of my inhuman experience during my detention on 2nd April 1996 to 2nd April 1997, both in Security Group Krikiri Maximum Prison. During this period, I was thrown into DMI Deadly Interrogation Tunnel 2 Park Lane, Apapa, for 7 days. An attempt to poison food for me at the National Intelligence Agency Kadrum.
Why do we waste time reading this? Is there anything here that is not here? Because it's called addendum.
My Lord, we may dispense with
Counsel for all sides. I don't really see why anybody will cross-examine a witness. The issues are so simple. If you were detained, which he said he was detained, was that detention unlawful? Was the arrest lawful or unlawful? Question of the rights he mentioned, are they gross violations? The word gross has been defined. And if you read our terms of reference, it mentions specifically murder, mysterious death, then gross. If they are read in para materia, it will be those that apply to the main thing mentioned before. So there's nothing really here that you cannot do by address. You don't need to cross-examine him. If you were detained, was arrested, was that arrest unlawful? If it's lawful, that goes. You detained, yes, was the detention illegal? If it's not, the whole thing collapses. So we make something that is so simple look so big. If I were a lawyer, I wouldn't cross-examine him at all. My Lord is one. But you want, yes, you want to cross-examine on what? There is no dispute that he was arrested, no dispute that he was detained. The only aspect that may be necessary is whether he was tortured. Now, I am not, this commission is not a court of appeal. to look into whether Aziza and others conducted the case according to this or that law. That's not our duty. We're not a court of appeal from the judgment of Aziza and others. No. So what concerns us is arrest, detention, torture. Question number 1, was arrest illegal? The answer is no. Question number 2, was the detention unlawful? Question number 3, is he entitled to all the claims in view of the fact that we're investigating gross human rights abuse? That wouldn't take more than 1 hour to finish this if it's a normal court and give judgment. Yes, anything more?
Yes, my lord, he has some documents to tender.
What?
He has some documents to tender, my lord.
To prove what?
Well, my lord, for what?
Arrest is a question of fact. Detention is a question of fact.
Yes, my lord.
Torture is a question of fact. You don't need document to prove it. Have you seen the document?
No, my lord. He said
and they want you to tender
award,
what you haven't even seen.
I was going to call for it.
Ask him to give you the documents. I don't know what they're going to prove.
Documents, please.
There's the charge.
I thought the charge was annexed to your petition.
Yes, annexed to the petition. There's the paper that the third one.
Can we address the court now? Or do you want to ask questions?
No, my lord. I just may want to assist the commission with a document to actually bring the
cross-examine. Go on.
Just to, I may pass it through the registry, but or maybe ask questions because he is not what he has claimed he is. That I know, and I have got something to that effect.
Well,
but to save the time of this commission, my
From
lord,
what he has read out, do you want to ask him questions?
No, my lord. I just want to give the findings which he deliberately omitted in his new petition. It will help to show that he was twice a convict, and that is where all his merits
Am I a court of appeal?
No, my lord. At least you know the person standing before
All right,
you.
tender the findings.
My lord, the witness has not finished his evidence.
Finished what? What else do you want him to say? Tell me what you want to get from him.
My lord, I was going to ask him to explain the issue of torture. He hasn't elaborated on that yet.
All right.
Which is what brings him under your lordship's jurisdiction.
Yes, you say you are tortured. Give evidence of the torture. That's all.
Yes, my lord. When I was taken to the Parkland detention in Apapa, I mentioned in my petition here, I am supposed to be a suspect until they find me guilty. But they put me in tunnel. I understand that you people have entered that tunnel. And if a human being can enter that place and come out, and I was left there for 7 days, I came out, I couldn't even know myself again. I think that is enough torture for a Nigerian in this country. What have I done that I have attended a party which I was entitled to, and that was part of the schedule of my duty, sir. And I felt by this alone, I wanted to read the addendum. There's a place I wanted to draw the attention.
Restrict your evidence to the torture. There you have a point. So don't talk about party torture. We're talking about torture. Why you went there is irrelevant. You were tortured. Give us evidence of this torture.
Sir, apart from when they took me, brought me out from the detention, from the tunnel.
For 7 days in a torture channel in the
Parkland, 2 Parkland.
All right.
Security
Parkland.
group.
All right.
They now took me again to when they framed charges against me for trial. I was taken to NIA GAT room. I pray nobody should experience that. That place is...
Do you regard the trial as torture?
Sir, it's torture, sir. They put me in that place.
Trial. Do you regard the trial as torture?
No, sir, not the trial. I was kept there. I was not tried.
I'm asking you to give evidence of torture.
So that's what I'm trying to give. I was put in a guard room waiting for trial in a small room that no human being could stay there. It's very narrow than this place. I could not even turn myself. I stood there. That is torture, sir. I understand this to be torture, my lord, because I could not even have a place to sit for 7 days, 3 more days. They kept me there. Nobody had visited me, nobody told me anything. Mentally, sir, I was confused. I was confused. I didn't know what to do again.
Yes? Yes, go on. Is that all the evidence of torture?
Another incident, sir. There was another incident that took place in prison, which I wanted to mention to this commission to listen to me. When I was taken to prison, there was another plan for me. I didn't know. I mentioned in my petition here, in my addendum, the publication that I was charged for espionage came out in a newspaper, only to be discovered by an officer who told me that they've been looking for me all these days. That if I was not lucky, I would have died in the first arrangement. That I was to be charged for espionage. And the Directorate of Legal Services, waived that out, that they should charge me for disobedience to standing order. That there were things packaged to set me on espionage so that they will take me out from the prison. So for 4 good times, military police officers were coming to prison every day to interview me on entirely a new issue that I knew about somebody who was doing 419. And this, the prison authority had to give special attention to my own case, keeping me entirely out of connection with other people until the present ADC to the head of state, Lieutenant Colonel Gewa Omu now, came on his own as the acting commander of the SIB in military police. The man arrived and wanted to carry out the investigation to know truth. That officer was able to discover that it was a plan, that I have nothing. Even at the time the man mentioned this thing, I was still in detention in security group. Therefore, there could be no way I could have connected with any human being. That matters.
You are kept incommunicado, yes. I've written that down.
Yes, sir. An officer came into prison from intelligence unit.
Major, the chairman has asked you to confine yourself to evidence of torture.
Torture. Every other thing is in your petition. We'll read it.
All right, sir.
But the one you have to give evidence on is on torture.
All right, sir.
Arrest, you have said it. Detention, you have said it. It's a torture.
Sir, Your Lordship, another point I want to mention, which was I know as tortured, was that when I came out of prison, I was warned that I'm being looked for again, that I should stay out of Lagos or anywhere. I remained in hiding because they wanted to still have their way. I could not even go out to anywhere. I couldn't connect with anybody. I was just hiding until I find my way out of Lagos. I knew even the intelligent boys came out and warned me. That alone, sir, I could not even go out. I could not even see my people. I was just kept in a hiding place that these people are looking for you to pick you up. Sir, that alone was a mental problem for me.
All right.
For Major, 1 year.
Major,
yes.
was there any sort of physical abuse?
Yes.
For instance?
Yes, my lord. The first day that I was taken to that place before I was taken into the tunnel, Frank Omenka, I pray he should be here, came to me and said, I should sit down in a naked, I should remove all my dresses, less my pants, and sit down on a bare floor. It was raining that day in Apapa. I remained there. He didn't talk to me. He didn't allow anybody to come near me. I remained there for close to 6 hours before at the night time he called one of the chaps to take me to tunnel. I didn't know what it's all about. Because
tell me what he said is physical abuse.
My lord.
You ask a question.
Yes, my lord.
What is the answer?
He said he was.
Paraphrase it for me, please. I can write it down.
He said he was meant to sit on the bare floor in his underpants, my lord.
And it was raining.
And it was raining. Were you, for instance, handcuffed or leg cuffed for an unduly long period?
Yes, my lord. During that period, they brought me out from tunnel. They kept me in handcuff and leg chain.
For how long, Major?
My Lord, it was about 3 weeks. I can't quite remember.
Continuously?
Continuously. I didn't eat there.
You didn't eat?
I didn't eat. I had to ask for food from my house because I realized that they were all out of me. And my hands in chains until one officer came and told them to please consider releasing me. It was the day General Sabo came to DMI that I think Omega realized that something was happening.
Continuously.
Yes, sir.
For 3 weeks.
For 3 weeks.
Yes.
But the day General Sabo came to visit security group, they quickly came to my place and said, remove this chain from his hand. And that was how I get out of the whole thing, with one other detainee.
Thank you, Major. Now, during your trial, were you represented by counsel?
I was represented, my Lord.
Okay. Yes.
I told you that I'm not a court of appeal. See? So evidence about what happened during the trial is not within our terms of reference. We're not going to review the findings of a military tribunal.
As your Lordship pleases.
I point, sir. Your Lordship, that day that I was detained, as soon as we came in from DMI's office, it's a distance from the security group. We entered the security group and Frank Omenka ordered that I should be taken to his office. There was one white man there. He carried a stick that he was carrying. He doesn't carry swagger cane. And hit on my head. He said, look at this madman. He attended a party with Americans. Nobody knows where he has his money. He hit me in the presence of the white man, and I felt sad. If I'm permitted to say something in this place, I will tell this commission so many things I discovered people are doing in the army. I was listening to so many officers, they were talking here, and I can say to them what some of them are saying were lies and some are true.
Any other thing?
Yes,
I've
finally,
recorded
Major,
about 6
yes.
examples.
One last question for you. Up to the point of your arrest, nobody ever informed you that. Up to the point of your arrest, nobody ever informed you that the party you attended was actually an illegal act in the military.
Next question,
nothing
please.
like that.
Next question, please.
My Lord, that would be all for him.
Yes, if counsel want to cross-examine, let them restrict themselves on torture. Any other thing is outside the powers given to us. We are not reviewing, and we cannot review the trial before a military tribunal. So torture, yes. Cross-examination?
Your Lordship. Please, Your Lordship.
On torture?
My Lord, I'm only formally announcing my appearance.
Are you cross-examining on torture? If so, go on, ask him questions.
Did General Ziza personally tortured you?
No, please.
Major Nyang.
My Lord.
Yeah, you just said that you were released from the bondage of chains when General Sabo visited the security group where you were detained.
My Lord, get it correct. When General Sabo was to visit that place, they hurriedly in the morning came to us and said, remove this hand chain from these people. Because I think they were afraid of General Sabo seeing us with the chain.
General Sabo, therefore, didn't torture you at all?
No, he didn't.
Your Lordship, we respectfully apply to close the case.
Mr. Inya, when you were invited to the DMI,
where is the clerk of court? Remind him if there's any other clapping, we clear the hall.
Yeah.
Any other shouting or clapping or noise, we clear the hall.
Clear the hall.
Please, no clapping, no shouting, no laughing even, please.
If they do, we'll clear the hall. Say it properly.
Please, no shouting, no clapping, no laughing.
We said
And anybody who try that, please.
we'll clear the hall.
We'll clear the hall, please.
Yes.
Thank you.
All right. Questions, please.
Mr. Nyang, you said you were invited to the DMI.
Yes, my lord.
Now, before you left, according to you, you went and told General Bamaiyi that you were invited to the DMI.
Yes, my lord.
Now, before you went to prison, after you went to the DMI, did you see General Bamaiyi again from that moment? After you had gone to tell him that you were invited to the DMI, did you, between that time and your trial, your detention, see General Bamaiyi, or did you go to tell him why you were being called?
My lord, I sent my family, my wife and my children, to go and meet General Bamaiyi because I was very close to him.
Did
I
you
worked under
see
him.
General?
I sent to him and he said nothing. He said he told them that they should go, that he has nothing to do.
Did you see General Bamaiyi?
As a person,
Yes.
no.
So while you were at the security group and while Omenka made you to sit on the floor when it was raining, General Bamaiyi wasn't there with you?
He wasn't there, but Omega said they phoned him to tell him that I had been caught, that Nadeko and the American spy is caught.
Okay.
He said so.
Okay.
There were officers there.
So when you were being tortured by Omenka and other officers, General Bamaiyi wasn't there with them?
He wasn't there. I believe he gave them orders because when they were talking telephones, I don't know what they were talking.
We are quite pleased with your belief, but you can keep it to yourself. Thank you very much.
States. I beg, help us.
With due respect, my lord, because of the fact that we're just giving this petition this morning, I glossed over it and there's one question more. I'm grateful. Major Nyang, look at page 1 of Exhibit 1. Page 1 of Exhibit 1. To be specific, paragraph 1 and the last 2 lines of paragraph 1 of page 1 of Exhibit 1. Have you seen it?
Yes, my lord, I've seen it.
To assist you, I will read those lines. The removal of my 2 cars and money from my residence by intelligence personnel on the orders of General Bamaiyi, Brigadier Patrick Aziza, Colonel Yakubu, and others. Then look at page 5, dealing with your prayers. To be specific, prayers C on page 5. That my personal belongings, which included 1 Peugeot 504 car, 1 Mercedes-Benz car, cash of 840,000 naira, and my other household property were carted away by soldiers on the orders of Lieutenant General Ishaya Bamaiyi, Colonel J.B. Yakubu, Frank Omeka, all of which are yet to be returned to me. So should I take it that General Aziza was not involved?
No.
Thank you very much.
No, you shouldn't take it that way.
Now, address
because I was told. My people told me that.
Address this, please. As I said earlier, if you look at the petition, 3 issues emerge. Was he arrested? The answer is yes. Was that arrest lawful, unlawful? 2, following the arrest, was he detained? Answer is yes, he was. Was the detention in the overall circumstances of the case lawful or unlawful? 3, was he tortured? I can't ask whether the torture was lawful because torture is never lawful. So if it's established that he was tortured, that's the end of the story. If the evidence before us is enough to establish torture. In that respect, I'd like counsel to address me on what is torture, legally defined. What is torture? Having defined what torture in law means, do the facts from Exhibit 1 and from his oral testimony and cross-examination amount to torture? Final question, who tortured him?
May I, with respect, sir?
Now, if you write out your
sir.
submissions on these 4 or 5 issues, submit them to our secretariat within, do I say 1 week? Is that all right, 1 week? Let me repeat the headings. From the evidence adduced from the petition Exhibit 1, was he arrested? There's no dispute he was. Answer is yes. Following from that arrest, he was detained. During the detention, he said he was tortured. Now we come to question number 2. Was the detention unlawful? I don't know whether you can make a distinction. Can an arrest be lawful and a detention unlawful? Add that. If an arrest is lawful, can a detention arising from that arrest be unlawful? Three, the trial before a military tribunal, whether it was wrongly done or rightfully done, is neither here nor there as far as we are concerned, because we can only investigate it if we're a court of appeal from that tribunal. Otherwise, it doesn't affect his human right position. Now we come to the question of torture. What in law is torture? Having defined torture legally, a subsidiary question arises. Will the facts deposed to by the witness and his petition Exhibit 1 in the circumstances of this case amount to legal torture? Now, his prayers, a man can claim the moon. We can't give him the moon. So nobody bothers about whether you claim 1 billion, 1 trillion. It's neither here nor there. Now, this question of his property seized, do they amount to gross human rights abuse? Even if they don't, is he entitled to have the properties back? That's all. So write your addresses along this line, answer the questions posed, then submit them to the Commission's Secretariat within 1 week. Does anybody have any problem with 1 week? All right. Within 1 week then,
My Lord, we apply that the witness be discharged.
He has no counsel. You are doing the write-up for him.
Yes, my lord.
All right.
Yeah. My lord,
Thank you very much. You are now discharged. Does anybody want to mention any case? How many SAN have we got here?
Only one, sir.
Only one?
Yes, sir.
So you're all alone?
No, sir. I have my juniors.
No, as SAN. There's no brother Silk?
No, not today, sir. Lord, I'm interested in case number 274, sir.
Call the case.
Petition number 274, Dr. Bay Koram Sankuti. 274, Dr. Bay Koram Sankuti. Petitioner present, my lord.
Appearances, please.
With profound respect to the Honorable Commission, I appear for the petitioner, Femi Falana. My learned friend, Mr. Olajide Bello, appears with me.
May it please my Lord and all the honorable members of the commission, I appear for the witness who has been subpoenaed ad testificandum and who is in court, sir. General Obasanjo.
Let's hear what he said. Who was
subpoenaed, sir, to come and testify.
Now you use one Latin word there.
Ad testificandum.
If you want to go
it's
Latin,
a subpoena,
go it properly.
It's a subpoena
ad testificandum.
Yes, sir.
That's the Latin.
Yes, that's
not
Latin.
subpoena testificandum.
Well, I've already...
Subpoena ad testificandum.
Yes.
Any other appearances?
With me, sir.
Hold on. Appearances first. Any other appearances?
No, I haven't finished, sir. I'm not appearing alone.
Your juniors. But that is in court. That's all right.
Well, I have Ola Sheni Okunleye with me. Adebayo Adenipekun. Ms. Remi Awe. And Audu Mai Kori.
With the greatest respect, my Lord, Bala Ibn Naala, I appear for ACP Zakari Bill, and I appear alone, my Lord.
Another person?
With profound respect to this commission, I announce my appearance for Major General Patrick Aziza. My names are Princess Monica Akiri.
Yes?
With utmost respect to your Lordship and the honorable members of the Commission, I announce my appearance for the Honorable Commission. My name is Mrs. Chinwe Uwandu. Mr. E. Ayakaka will be appearing with me.
Yes, let's settle the issue of appearances. You have the petition. You have the petition. Can you read out the portion that Zakaribi was mentioned in the petition so that we know what we are talking about. Page what? If you can mention the pages of the petition so we know in what capacity it was mentioned. Yes? Page 6. Hold it. You haven't finished, you're sitting down. Page 6. I say, show me. Then you read that to me, what was said about the recommended action is different from what some people did to him. So if recommended action does not reflect what a perpetrator did to him, I cannot say that his human rights have been violated.
Well,
He's helping us how to write our report, so we thank him for that.
May I say something, my lord?
I recommend, go and read out what he says.
2 specifically said, General Ibrahim Babangida and ACP Zakari Biu should explain why I was dehumanized.
I see.
And detained without trial from July to August 1993.
All right.
And my lord will remember I appeared for this for the last time.
You cross-examine him.
Who, my lord?
The petitioner.
Yes, my lord, I did.
Good. Yes. Who again? Princess?
Oh, my lord. Copiously, my
What
lord.
and what pages of the petition did they mention your client? So that we know.
My lord, page 7.
Page 7. Read out what they said about your client.
Suggested course of action.
Suggested.
Yes, my lord.
Are we bound to accept his suggestion?
Well, apart from the suggestion, my lord, before
We're not
then.
Yes?
Well, your lordship will recall that, in fact, I cross-examined.
Read out what they said about your client.
Yes, my lord. Suggested course of action. The proceedings of the Special Investigation Panel and the Special Military Tribunal, for that is where my client comes in, were recorded on video and tape recorded. These should be recovered and played publicly to show how supposedly responsible persons behave with impunity when entrusted with matters that bother the matters of life and death and the liberty of the citizens. General Mujakbero should then explain what grounds I was referred to the SMT. Number 2, General Aziza and his judge advocate should be asked to explain their disgraceful behavior during the trial and how they came to the verdicts they reached. My lord.
Did you cross-examine?
I did.
You did?
I did.
And you put all these facts to him?
Of course I did.
So you don't need any further cross-examination of the witness on these facts?
My lord, the petition, I'm appearing in respect of the petition, my lord. When the petition is...
Yes, my lord. You have cross-examined the petitioner in respect of all these facts, the allegations he made against your client.
Yes, my lord.
Did you cross-examine him?
I did.
Yes, that's all right. We want to know what the facts are before we start.
Well,
so the facts are that you did cross-examine.
Yes, my lord.
And counsel for Bamaiyi also cross-examined.
We did.
All right then. No, not you, but Allah. No.
Yes, my lord.
He's so black we don't see him easily.
Yes, my lord. My lord, may I add that at page 7, paragraph 1B, Brigadier General Sabo, Colonels John Olu and Frank Omenka, and ACP Zakari Biu, again mentioned, who are responsible for investigation, arrest, and treatment of accused in custody.
Yes, thank you. You cross-examined too?
I did, my lord.
Good. Yes, Babalola, you stood up.
My Lord, as I said earlier, sir, we are here in obedience to the subpoena issued by this Honorable Tribunal, dated the 21st of August, 2001, sir. My Lord, my client, sir, is here physically in view of his commitment to rule of law, he being an apostle of rule of law, he being a crusader of rule of law, and well, I don't know, I have to shout now. I think something is defective here.
If you shout, it's all right. We won't send you out because you are cancelled. But if they shout, we send them out.
Yes, as I said, sir, my client is here physically, sir, because he believes in the rule of law, sir. He's an apostle of it, an advocate of it, and a crusader of it, sir. And however, sir, when the subpoena was issued, the 21st, my client wrote to this tribunal to ask for particulars. The subpoena was not accompanied with any document. The tribunal was good enough and gracious enough to send all necessary processes. Having given due consideration to the contents of the petition, we find as a fact, and having regard also to the provisions of section 5A and C of the Tribunal Inquiry Law, part Cap 447, that even though, sir, the tribunal has a right to issue subpoena, we believe that our client, sir, is not in position either to give useful evidence or relevant evidence. I want to read, with your permission, sir, the provisions of section 5A and C, sir. Subject to the provisions of this act, a tribunal shall have and may exercise any of the following powers. That is to say, A, the power to procure all such evidence, written or oral, and to examine all such persons as witnesses, as the tribunal may think it necessary or desirable to procure or examine. Caesar says the power to summon any person in Nigeria to attend any meeting of the tribunal, to give evidence or produce any document or other thing in the possession and to examine him as a witness, or require him to produce any document or other thing in his possession, subject to all just exceptions, underline, sir, subject to all just exceptions. Summonses issued under this paragraph may be in this exclusive form. My Lord, the composite effect of both section 5A and B is that the witness to be summoned must be somebody who, to your satisfaction, has relevant and useful evidence. Now, my Lord, we are therefore applying, sir, that my client, sir, is not the type of witness envisaged under section 5 of Cap 447, sir. And to this end, we have sent to this Honorable Tribunal a petition dated, excuse me, the one I marked, yes, dated 6th of September, sir. And we have also served a copy, sir, on the petitioner, and I have a copy of a document showing that it was duly received. But that notwithstanding, counsel for the petitioner, the highly respected Falana, discussed with me, and I knew he arrived this morning from Lagos, so he's aware of the content, sir. May I therefore apply, sir, that my client comes to the witness box and permit me, sir, to raise this objection viva voce through the...
What is he doing in the witness box when you are raising an objection? You raise objection first. We rule on the objection before he goes into the witness box.
The reason, sir, is this, sir. While reading it, sir, I want to tender the Tribunal of Inquiry report, which was never tendered by the petitioner, which he knows. Two, sir, I also want to tender, sir, the finding of the tribunal and also the white paper on it, which he knows.
Time. You say you discussed with your learned friend.
All
that? These are issues of law and legal documents. You can take them from the bar.
Well, if
you don't need him there to tender them.
Fair enough. So if your lordship permits me to do that, I will do that, sir.
Yes.
Okay, fine.
You can tender all relevant laws from the bar.
Very well, sir. I take it, sir, that your lordship permits me now to...
Yes.
Thank you, sir.
The law permits you.
Thank you, sir. No, I'm talking about my petition itself, sir. Now, the petition, our opposition, sir, reduced the writing, sir. Dated 6th of September. It's already with the commission, sir. And I refer to it, sir. The heading is Protest Against the Witness Summons issued to Chief Olusegun Obasanjo, GCFR, President, Federal Republic of Nigeria. We are counsel to Chief Olusegun Obasanjo, GCFR, the President of the Federal Republic of Nigeria. On or about the 21st day of August 2001, the President was served with a witness summons to appear before your commission in respect of the petition brought by Dr. Beko Rasamkuti and family.
Volume, sir.
As stated by His Excellency during his first appearance before this tribunal last year, the President is a firm believer in the rule of law, which is the bedrock of democracy. Without any doubt, the survival of the present democratic governance in our country is hinged on the due performance of the rule of law. Accordingly, the President will appear before this tribunal in obedience to the summons. And indeed, sir, it's right here in this court hall, sir. And in accordance with his duties to protect, observe, and obey the Constitution and other laws of our fatherland. Indeed, the vitally important difference between a democratic government and dictatorial government is that in the former, nobody is above the law. The appropriateness of the summons to Chief Olusegun Obasanjo, without prejudice to the above, it is important to state that having regard to the materials before this panel, that is, petition and the evidence given by Rasom Kuti, our client feels strongly that is at a loss to understand what must have informed the request for the petitioner that he be summoned before the commission. For a person to be qualified to be invited as a witness, he must be able to give evidence as to the facts in issue. The mere fact that a person is the head of an institution, indeed in this case, the mere fact that is the head of state, at a time when an event occurred, does not, ipso facto, make or constitute him into a relevant witness. If that was so, all it means is that whenever any person under the head of state, General Olusegun Obasanjo, commits any crime in Ado-Ekiti or Oputa, then he should come and give evidence. Or Oputa, thank you. So, sir, Your Lordship, I hope somebody has interjected, sir. Whenever anybody commits offense, even in Oputa, then
I can assure you that at least the president won't commit there.
Or the head of state being the head of state should be a vital witness to be subpoenaed in respect of the arrest of Segun Adams and the torture which he complains of somewhere is now. Now, facts which render our client an irrelevant witness, the locus synchro, that is, Agigim Motor Road, where the event happened. 1, the subject matter of the petition occurred on 18 February 1977 at about midday, broad daylight. 2, sir, it is not in dispute that it was the refusal of one Segun Ademola, the petitioner's employee, to obey the order of the military police who was controlling traffic that led to the fracas. All that happened was that the traffic police demanded that he should see the plate number of the vehicle because he wasn't carrying one. He refused. And the traffic policeman said, "Give me the key of the car." He refused. The other man ran into Kalakuta house. The police stood in front of it, and then he started to move backwards. That's the evidence before your lordship. That was how the thing happened spontaneously. When they were about to drive him into the Kalakuta Republic, he immediately blew his whistle, and others joined. That cannot be a matter which head of state at the Don Barras at that time would have instigated. 2, sir, it is not in dispute that was the refusal of Segun Ademola, the petitioner's employee, to obey the order of the military police who was controlling traffic that led to the fracas. It's also not in dispute, sir, that the military police called in his colleagues who were within reach for assistance to apprehend Segun Ademola, who was in the car with the driver. 4, the action of the military police and his colleagues was clearly, sir, to a reasonable person, even to a market woman, spontaneous and without any premeditation. Therefore, my client could have not been the person who instigated that, sir, and cannot give evidence of that. 7, sir, our client was 5, rather. Our client was not present at the scene from all the materials before your lordship, sir, and had nothing to do with the incident, and therefore cannot be a relevant witness with respect to the event that occurred at noon on 18th February 1977, sir. Now, following this, sir, the petitioner went to court immediately, sir, when the matters were fresh. And he sued those people he knew who did it. He joined both Ademola and as plaintiff for Trevor and his family. And then the military police and other police officers involved, he went further, sir. This is the curious aspect of it. He joined the commander of Abati Barracks, which is directly opposite the place. Now, not only that, sir, he joined the Ministry of Defense, which is the employer of the military, sir. And what happens, sir? Your lordship will see. Now, the petitioner and 2 other members of his family instituted an action in 1977, immediately after the event, when the facts were still fresh in their memory, and joined as defendants persons they considered, I emphasize, sir, they considered as relevant to their case. My lord, my client was not joined. 2, these defendants included the persons they identified as those who carried out the act, as well as their commanders and their employer, Ministry of Defense. They neither joined our client in the action, nor called him, even, sir, as a witness. Underline, sir, not as a witness. Because, why, sir? They knew that he was neither involved nor relevant. 3, sir, more importantly, the plaintiffs in the action withdrew their claims against the Ministry of Defense because they were not relevant to the case. That was their own action, sir. The employer was the defense. They withdrew on their own. 4, sir, the court also found that the soldiers who carried out the act were not instructed to do so by their commander, and that they were acting on their own that finding of the trial court, which was confirmed by Supreme Court, is consistent with the behavioral patterns and attitudinal disposition of Nigerian soldiers during the military era. Everybody here knows what soldiers were at that time, sir. Again, how come? Now, you didn't invite my client as a witness then? You didn't join him then? Today, because the Oputa tribunal is sitting, now you say he should come. Now, I refer, sir, to page 12 of the 22. And Lord, the petitioner was good enough, sir, to attach as appendix 2 the judgment of the High Court in Lagos. And I want to read from it. What if they had been good enough to point out to this tribunal, this subpoena would never have been issued, sir. I read, sir. This is his own judgment. It seems clear to me that whatever role these named officers played in the whole sordid incident, they do not come near the allegations in the pleadings that they burst into the house and maliciously set fire to it. I add further that there was no evidence that they ordered the soldiers to do so either. All that means is that they were acting on impulse. They acted the way they used to do things. My client was not involved. Having found that they acted on their own, having found that even the commander on the spot was not involved, how come now to go to the very sky and bring the head of state to come and give evidence on this? Now, it is instructive, sir, to know that the Honorable Chairman, not only that, before I go to this, sir, he appealed to Court of Appeal. Then he appealed to Supreme Court and lost all the way. The judge, those who sat in the Supreme Court, which is the apex court of the land at that time, sir, included some of the most brilliant judges we have ever had, sir. One, Irikefe, yes, sir. The erudite Justice Shaw. Of course, you know Justice Coker, sir. And the Professor Carby White, who's still there. And last and not the least, the Socrates of our Supreme Court, the philosopher, the historian, Oputa Jesse. I tender the judgment now, sir. No, I tender it now. That's a judgment, and you affirmed it. What did you affirm? You affirmed that the soldiers acted on their own. You affirmed that the commander did not know about it. You affirmed that the Minister of Finance didn't know anything about it. How come you invite my weak client to come and be witness today? I tender that.
What president would that be? It will be two.
I will tender it. We do it with your permission. And last, sir, I don't know whether it has been marked, sir. Exhibit what? Exhibit 2.
Somebody on this side is asking a question. Is the chairman not disqualified from sitting? Having sat in the Supreme Court.
Incidentally, sir.
On the same facts.
This is a truth commission, sir. Number one. Number two, sir. If a judgment, sir, amounts to rest with the sir, it doesn't matter whether a man sits on it. I mean, we can't change it. In fact, that's what next thing I want to say, sir. 6, how it can become relevant today be the imagination of everybody. The fact that the soldiers were acting on their own in 1977, sir, as found by the 3 courts and by another tribunal of inquiry, which I'm going to tender, sir. It's a fact that did not change then, has not changed, and will never change, even before you. Now, sir. My Lord, sir, 2 years after the event, in accordance with his own petition, he now filed a petition addressed as Exhibit what, please? He filed a petition, sir. He served it on, it's important. It's Appendix 1, sir, to his petition, sir. The heading is important. It reads, Petition to the head of state and commander-in-chief of armed forces. He happened to be the head there. He said, Dash, Lieutenant General Olusegun Obasanjo. Now, what is complaining of today here, before your lordship, sir, is that my client did not reply to that petition filed 2 years after the event. Now, our answer, which is clear also from the material before the court, sir, is that the petitioner's appeal against the judgment of the High Court was still pending before the Court of Appeal at that time. Indeed, sir, he appealed from that one. It was not, your lordship did not deliver your message, your judgment until 1985. In other words, up to 1985, even if my client was still in office in 85, in 84, for instance, he could not deal with the petition because the matter was sub judice. The trial court had already made findings exonerating the government. And while that judgment was still subsisting and was subject matter of appeal, our client could not have constituted himself, sir, into a concurrent court of appeal. So we have the Court of Appeal set up by the law. Then you have Obasanjo's Court of Appeal together. That can never be to run against common sense, logic, and law. The petition, therefore, at that time, sir, as we usually say in this profession, amounted to forum shopping for release both in the court and at the administrative forum. You can't have the two together, sir. I.e., the head of state. Therefore, it was appropriate for our client not to have replied the petition at that time. Accordingly, if you start to have reacted to the petition, would not make our client a relevant witness before the tribunal. 3, sir, it is instructive to state that the petitioner failed to tell the tribunal that there had been an administrative inquiry into the Kalakuta Republic incident in 1977, therefore making this petition irrelevant and an abuse. The Board of Inquiry made damaging findings against the petitioner and his family. The government later issued a white paper on the report of the inquiry. Now, the petitioner knew this, and he did not inform your lordship about the existence of this document. Now, I want to please, before your lordship now, this is a certified true copy, sir, of the report, the whole proceedings, and the findings. Attender, sir.
Mark it Exhibit 3.
I also have before me, sir, a document dated 23rd of April 1977, sir, which is a memo by His Excellency, the military governor of that state, Lagos State, sir. And I have a certified copy of it again, which I tendered.
Memo.
Then the white paper, which was given, apart from the fact that was issued, it was given the
Memo was
widest.
before.